So let's review our timing issues, answers, and amendments as the final discussion of the pleadings part of the lawsuit. So when you make a motion in response to a complaint that precedes the answer, a pre-answer motion under 12b, you are allowed to join all of the arguments that you have against the complaint in one motion under 12b. So whatever arguments you have that fall under that list under 12b, you can make them all at once. And in fact, you must make them all at once. You have to put all of them in one motion to dismiss, because Rule 12g2 says you must not make another motion under this rule. That restriction does not mean that you cannot make the same argument in other places, but it does mean that your pre-answer attempt to get rid of the lawsuit before you even get into it is a one-shot sort of situation. That's under your 12b motion. Rule 12h describes how each of the 12b arguments or affirmative defenses can be raised and the timing for in which they can be raised. So as we talked about in class, subject matter jurisdiction can be raised by anyone at any time, including the parties and the court of its own accord. That's a really special one. And the reason for that is that subject matter jurisdiction goes to the authority of the court to hear the case and make a determination. If the court lacks authority to make a determination in the case, then the judge is just some person who says something about the case. They don't have any legal authority to resolve the litigation. And so the case has to be dismissed if there's no subject matter jurisdiction, regardless of anything else. So one way of talking about this is that subject matter jurisdiction is not waivable. It's not an argument that you can waive because it's a responsibility or a constraint on the court rather than anything that the litigants can control. In contrast, lack of personal jurisdiction is just the opposite. It is highly waivable, and if you don't raise it in your first communication with the court, then you have, in fact, waived it. So whether you're raising lack of personal jurisdiction in a 12b2 motion or in your answer, it has to be the first thing you say to the court. Improper venue, insufficient process, insufficient service of process, those are things you can raise in either a 12b motion or an answer. Failure to state a claim and failure to join a party, you can raise in a 12b motion, in an answer, at trial. And actually, there's another one which is less common, I don't have it on here, which is for a judgment on the pleadings under 12c, which is basically a request to determine the case without evidence. So someone asked, what does that leave? So when can't you make this motion, and how does this differentiate it from subject matter jurisdiction? And the answer is basically that there's a long period between when the pleading stage closes and the trial begins. And that period comprises discovery, which is usually at least a couple of months and often much longer, and then a period after discovery where people are making and responding to motions for summary judgment, so based on the evidence, and preparing for trial, making pretrial, conferring pretrial to determine the trial plan, and so on. And the idea is that you shouldn't be clogging up that process with these motions, although you can raise them at trial and appeal on that basis as well. Okay, so those were pre-answer motions. Now we're into answers, and we talked about how an answer has to address each allegation by admitting it or denying it, how failure to admit or deny counts as an admission. And so if you're not sure, you might want to say, I lack information upon which I can admit or deny this, therefore I deny it. Just in case, to preserve that denial, because you can always admit it later. But in order to get rid of an admission, as you saw with Beek, you need leave of the court or the adversary's agreement. So I'll talk about that in a sec with Rule 15. But admissions bind you more than denials. So with Zielinski, we saw how to be effective, that is, to be sufficient, an admission or denial has to not just admit or deny a paragraph in a complaint. It has to actually put the plaintiff on notice of defendant's argument in a way that's relevant to plaintiff's claims. So you'll recall in Zielinski, the defendant did not lie in its response to a big paragraph of allegations, but it sure made it seem like what it was denying was its employee's negligent injury of the plaintiff, and not that the person who negligently injured the plaintiff was its employee. So we also discussed how, as a practical and strategic matter, as a plaintiff's lawyer, you just don't want to have a paragraph like that that has allegations embedded as assumptions into a fact statement paragraph. Separate them out, figure out what you're assuming, and say it as an allegation, even if it seems really obvious, because that gives you an opportunity to figure out what exactly it is that the defendant is contesting and what you can assume through the litigation and don't need to make arguments about or collect evidence about. An answer is also a place for affirmative defenses, including those listed under 12b. So here's another place where you can make those arguments, even though it's not a motion to dismiss. And other affirmative defenses as well, not listed under 12b. And for these, you can imagine something like, oh, a statute of limitations, we talked about that. So sometimes you can make that argument under 12b-6, failure to state a claim because the limitations has run. You can also offer it here. Something like assumption of risk. You know, you signed a form saying that you assumed all risk of going on my ice skating rink or whatever. And so you have no claim because you've signed your right away. You've waived your right, stuff like that. Finally, we talked about amendments. So a complaint and an answer is subject to amendment under Rule 15. Within 21 days of serving either, you can amend it as of right. You don't need to ask anybody's agreement or permission. Once that time has passed, you can amend only with the opposing party's consent or with leave of court. And the rule is that the court should allow amendment freely when justice so requires. So we wanted to know, how do we know if justice requires it or not? And Beek helped us figure that out. So courts should not allow amendment if the person making the amendment has displayed bad faith. So they've delayed making an amendment. It seems like they are doing it with an ulterior motive to get out of something, or they've been aware of it for a long time and they have failed to cure the problem. Futility, so sometimes there are things that might be wrong in my complaint or my answer, but it doesn't really make that much of a difference to the litigation as a whole. So if the amendment isn't going to make a big difference, make a material difference to the litigation, there's no point in allowing the person to amend. And finally, what we really were concerned with in Beek, undue prejudice to the other party. And that party has the burden of showing prejudice. So in Beek, the court really had to weigh the prejudice that the plaintiff felt, so the harm to the plaintiff of allowing defendant to amend, with the prejudice that defendant had from not being allowed to amend. And basically in Beek, the result there was, well, if we allow defendant to amend, then plaintiff doesn't have anyone to sue. There's no relief for plaintiff here because Aquaslide isn't the right defendant, and we don't know who the right defendant is, and anyway, it's too late to sue them. So that's a lot of prejudice for a plaintiff to bear. On the other hand, Aquaslide, the defendant, if they were not allowed to amend, they would be potentially held liable for something for which they actually had no liability, for which they, in a situation where they didn't breach a legal duty because they have no legal duty to people who buy other products than the ones that they produce. And the court basically decided that Aquaslide would suffer greater prejudice from not being allowed to amend than Beek would suffer from allowing Aquaslide to amend. One way to think about the rationale there is to remember that in litigation, the default assumption is that the defendant is not liable unless the plaintiff can overcome that presumption by a preponderance of the evidence. And so siding with Aquaslide in the amendments question, in a sense, preserved their default position of non-liability rather than imposing liability where there was actually, as a factual matter, no legal breach. Finally, we discussed 15C, which allows something called relation back, where you can substitute an allegation, and especially a party, even if the statute of limitations has passed, and the court will treat it as though that party had been there from the beginning under certain circumstances. And those circumstances are that the situation out of which the claim arises is the same situation, that the party you're adding or replacing or substituting for another party had enough notice such that they're not at a disadvantage in mounting their defense, and that they knew or should have known that the action should be against them, but for the plaintiff's mistake. So we discussed how the plaintiffs in our cases would fare, and we decided that had Rule 15 been available when Zelinsky was heard, that would have been a really good candidate. And in fact, Zelinsky is kind of the prototypical situation in which you'll find Rule 15C being used. You have two corporations that are very closely related. In this case, they're covered by the same insurance company. They're clearly in contact with one another. It was a little bit confusing which corporation actually employed the person who was alleged to have done the harm. In fact, that person themselves didn't know who employed them. They hadn't been told that they had a new employer. So all of the requirements of Rule 15C relation back seem to have been fulfilled. The company, the correct defendant, was in fact not prejudiced. They were well aware that they were the ones who should have been sued and not the other guys. And they realized that it was plaintiff's mistake, that that was the only reason that they were not being sued. In contrast, the plaintiffs in Beek didn't know who the correct defendant was, and even if they were able to find that correct defendant, there's no indication that that defendant, despite the bad things they'd done in producing defective water slides, there was no indication that that defendant knew that that lawsuit was going on and that they should have been the defendant rather than Aquaslide. So Beek is a much weaker case and doesn't really fit the Rule 15 requirements, even though it arises from the same transaction and occurrence. And even though it might seem like it would be more fair to allow it to be used in that situation. Finally, I asked you guys about John Doe defendants. So often law enforcement officers, but also often other personnel in an institutional sort of situation where the plaintiff can know that the person, for instance, was employed in a certain capacity or was present in a certain place but doesn't know their name. And it seems like 15C relation back would be a good bet for those cases. But as we've seen, many courts interpret this last provision that the new party should have known that the action would be against it, but for mistake, to require a mistake rather than a lack of knowledge. So having a John Doe defendant effectively saying, I know this defendant is a security guard or a police officer, but I don't know their name. That's not a mistake. That's accurate. You don't know their name. And courts won't allow 15C amendments to replace that John Doe with an actual name. There's a little bit of non-unity on this point, especially after that Krupski case that I discussed in class. There are some district courts that have been allowing this based on Krupski's statement that what matters is not the state of mind of the plaintiff, but the state of mind of the defendant. But so far, the circuit courts that have ruled on this have agreed that you cannot replace John Doe defendants with actual names after the statute of limitations has run under 15C relation back.